Good afternoon, everyone. This is Ken Murphy from GP Connections. Just like to welcome you to today's webinar presented by Lisa O'Neill from Murdoch Lawyers. There will be people joining as we go along, but just for the benefit of everyone else, so that we can still finish on time, we will get it going. And just a reminder as well, the bottom left-hand screen, there's a chat box. You can type any questions in there, and Lisa will be able to answer as we're going. I'll hand it over to Lisa. Thank you very much.
What I'm going to talk about today, and the example I'm going to use, relates to the family court because my background's in practice in that area, but the concepts and principles that I'm going to discuss are relevant to any court, whether it's the Supreme, District, Magistrate Court or tribunal such as QCAT. So if you serve with a subpoena for one of those courts or tribunals, the general principles will apply, but you should check with the relevant rules. So as you can see, subpoena is a really old word, a very old legal concept, and it comes from the Latin word under penalty, which I think is fairly appropriate given that if you ever served with a subpoena, you'll understand that the requirements are very onerous, and it probably feels as though you're the one rather than the litigants who are being penalised. So just to give you an example, put yourself in Dr. Busy's shoes. It's 9 AM on a Friday morning and Dr. Busy's surgery waiting room's full. The receptionist's called in sick and Dr. Busy's waiting for the temp to arrive. A process server arrives with a subpoena to produce documents in the family court in Brisbane next Wednesday. Attached to the subpoena is a cheque for $5. The patient records sought relate to Mr. Pooley, a patient of Dr. Busy, and he's seen the Busy family for many years. Dr. Pooley and his wife are involved in proceedings in the family court related to their children, a property settlement and spousal support for Mrs. Pooley. The patient file's huge and there's no way that Dr. Busy can get the documents to Brisbane for $5. So what can Dr. Busy do? So what the court has said about subpoenas is the purpose of the process of a subpoena is to facilitate the proper administration of justice between the parties. For that purpose, it's the policy of the law that strangers who have documents may be put to certain trouble in searching for and gathering together relevant documents and bringing them to court. It's according to the same principle that persons who have knowledge of facts are put to the inconvenience of being brought to court and required to give evidence. So although Dr. Busy isn't a party to the proceedings, Mrs. Pooley, who is a party to the litigation, can ask the court to issue a subpoena according to the rules of court, and the duty owed by the person receiving the subpoena isn't to Mrs. Pooley or to Mr. Pooley for that matter, but to the court rather than the litigant. So you might wonder why it is that lawyers are putting you to all this trouble and asking for all these documents. And the answer to that is in Section 48 of the Evidence Act. So as you probably know, the rules of evidence determine how parties give evidence in courts and tribunals. And generally in federal courts, people give their evidence on affidavits, which is short sworn statements. So unless you've provided a medical report and are required to give an affidavit annexing it, it's very unlikely that you'll actually be subpoenaed to give evidence. But if you're actually issued with a subpoena, you're entitled to reasonable transport costs to and from the court if you're being subpoenaed to give evidence. You're entitled to stay overnight in reasonable accommodation. So you probably won't be put up at the Stanford Plaza or driven in a limousine, but something like the Novotel and a cab fare to and from the court would be regarded as acceptable. You should know, however, that courts usually give professional witnesses leave to attend by telephone. So if you're ever asked to give evidence in court or subpoenaed to give evidence, you should see if it's possible for you to have leave by telephone so that you're not away from your practice for as long. But getting back to why it is that you have to produce all these documents, basically the rules of evidence in the Evidence Act are that if you, a lawyer tenders a document, so for example, Mr. Pauly's medical reports, then the truth of what's in those documents is generally taken to be accepted. So instead of having to call you to give evidence to say that you treated Mr. Pauly and what his medical condition was, or what medical specialist you referred him to, or what the side effects of his medication were, or any of those sorts of facts, subpoenaing the documents and tendering those documents to court would generally be enough. So the answer in this case is, for example, the documents would probably prove that Mr. Pauly attended on Dr. Busy to complain of chest pain, that he was referred to a specialist for treatment, that the specialist's opinion was that he suffered from a medical condition and required him to take leave from work for a period of time. So this is quite important from a legal perspective, because without the documents establishing those facts, such as a specialist report, it might be necessary to call Dr. Busy and the specialist to prove those facts, which would be a time-consuming and expensive process. Now, you're not required to comply with the subpoena if you haven't been properly served, and you should know that the rules actually require personal service, which is why in the example a process server actually attended on the office, and you're not required to comply if proper conduct money hasn't been tendered at the time of service or shortly thereafter. So this is an example of what you would see when you were looking at the subpoena. So if you've ever been served with a subpoena, it should have either a schedule or a list of documents which tells you what it is that's being sought. So you'll see in this example there are 3 classes of documents that were sought from the doctor. The first one clearly relates to the patient, and you know which you should be able to identify which patient records they are because you have the name of the patient and his date of birth. But you'll see from that example that they haven't just asked for the patient's medical records, but they've asked for every single class of document you could possibly imagine. So letters, deeds, file notes, facsimiles, emails, etc., etc. They've also asked for a list of medication that he's been taking for the last 5 years, and they've asked for copies of all of the Medicare claims and Department of Veteran Affairs claims that Dr. Busy's made with relation to this patient. So what is it that you actually have to produce? And this is really a key concept. If you remember nothing else, just try and remember these 3 words. You have to produce documents that are in your possession, power and control. So possession is pretty obvious. That's a document that you have, that you hold. But power and control means a document that you could get. That said, subpoenas are read strictly. So you'll note that in example 1 of the schedule, it's only seeking documents related to Mr. Pauly and not documents related to Mrs. Pauly or their children. So in those cases, you don't have to provide any of those other documents related to the rest of the family. Now, with respect to item number 2, you'll see that it's asking you for a list of something, and it's fairly unlikely that you'd have a list of that medication readily available. That's something that you could do if you had the time, but you're only required to produce a document that actually exists. You don't have to manufacture a document. So in those circumstances, you don't have to comply with 2. And we'll come back to items 1 and 3 because you would be able to object to those for another reason, which we'll come to in a moment. So what do you do if you're served with a subpoena like that hasn't had proper conduct money, wasn't served within time because the rules say that you're required for 7 days notice, and was really wide, if you remember back to Schedule 1, it asked for a huge number of documents, which would probably take you a long time to compile. So if you want to object, the important thing to remember is you have to do that at the return date of the subpoena. I've been involved in matters where doctors and other people have produced documents, but then they waited until after the subpoena was returned to complain about the conduct money they were given or object on some basis. And if you do that, it's too late. You need to do it at the time of the return date. And if you don't, you lose the right to claim proper conduct money and costs, and a warrant can issue for your arrest. So what's the basis of a proper objection? Generally, objections could be made on the basis that the subpoena is oppressive, and oppressive and too wide have fairly similar meanings. So if we go back to that schedule which asked for that huge list of documents, most of those, if they exist at all, probably have nothing to do with the issues that are before the court. So that subpoena wouldn't be allowed to, or you could successfully object to that subpoena on the basis that it was oppressive or too wide. It's also an abusive process if the documents are irrelevant. So the courts have been really clear that you can't just go on a fishing expedition hoping that something will turn up. A good subpoena should be very carefully directed with some idea of why it is that the documents that are being requested are relevant to the issues in dispute between the parties. And obviously you can object if you haven't been provided with sufficient conduct money. Now, if you're served with a subpoena from the Family or Federal Circuit Court, you'll see in that document, in Part F, there is a part in there which you can use to object. And it's very straightforward. Basically, you just have to complete your name and then the basis of your objection. So, for example, it was too wide, the documents don't exist, I didn't get proper conduct money, or whatever the basis of the objection was. But strangely, even though you're objecting, the rules actually require the documents to be produced at court by the due date so that the registrar or judicial officer can make a decision about whether or not the document should in fact or can in fact be objected to. So the best idea before you get to that point and are put to the trouble and expense of producing those documents is to contact the party who issued the subpoena to see if the scope of the subpoena can be narrowed. So I've had lots of matters where the receptionist telephoned and said, look, you know, we've only seen this patient for the last 3 years and these are the type of documents we've got and what is it that you're interested in? And generally we can agree on narrowing the scope of the subpoena so that you're not put to the trouble and expense of collating all those documents. Or alternatively, it might be that you contact the person and say, look, you know, this is a huge file, I can't possibly get it there for that amount of conduct money, that there's a courier available, it would cost X. and the person issuing the subpoena would then arrange to pay you a proper amount so that you were able to comply. And if you're able to do that, then you don't need to proceed with the objection. The solicitors would then appear before the court and make arrangements to inspect and copy the documents, and we'll come back to that process shortly. But the other reason it's really important to try and narrow the scope of the subpoena before you comply, if possible, is that it'll put you in a better position to get costs if you need to do so. And those costs can be quite significant, as we'll see shortly. So this is an example of that notice to objection. This is what it looks like. So you'll see that on it has to the registry manager at Brisbane, and as you probably know, the federal courts are located in various locations. Even in Queensland there's a registry in Rockhampton, Townsville, Cairns. So whichever registry it is, your name and then why you object to the subpoena. So you'll see here that Dr. Vizzi's objected because he wasn't tendered with proper conduct money, and he's saying that, you know, the grounds of the subpoena were oppressive, too wide, an abusive process, and amount to phishing. Now, the first test the court has to decide when deciding whether or not an objection to a subpoena should be upheld is whether or not the documents were relevant. So we know that the courts have said that the purpose of the subpoena is to facilitate the proper administration of justice between the parties, but because the person receiving the subpoena is generally a third party, so not someone who's a litigant in the proceedings, the courts have said that you can't use a subpoena as a way of getting disclosure. So in other words, if the parties have the documents themselves, the first port of call is them. They're the ones who are supposed to disclose them to the other. When the court's deciding whether or not a document's relevant, it'll look at all the circumstances of the case and look at the relevance and importance of the documents and weigh that up against the hardship likely to be caused against any prejudice and hardship to a third party by failure to disclose. So to give you, going back to the Dr. Vizzi example we had before, it is likely that the medical records for Dr. Vizzi would be found to be relevant because in property proceedings the court would be considering issues such as Mr. Pauly's earning capacity, his health, any special expenses he has, for example, related to his medical condition. So the medical records would be regarded as relevant, but all those other documents we've talked about in Schedule 1 wouldn't be regarded as relevant because there's no clear link between any evidence related to Mr. Pauly's medical condition and that huge list of documents that have been sought. So many of those documents are unlikely to be relevant to the issues in the dispute. For example, how Mr. Pauly's medical condition affects his earning capacity. So because that subpoena was drawn in the widest possible terms, requiring every class of document, including those letters, file notes, facsimiles, emails, without any sort of qualification or suggestion of relevance, those documents would be likely to be regarded as a fishing expedition, and therefore you'd be able to successfully object to that subpoena. And if you remember back to that schedule, you'll remember that in Schedule 3, they weren't asking for documents related to Mr. Pauly, but we're asking for documents related to the doctor's claims for veteran affairs and Medicare payments. And obviously those documents have nothing to do with Mr. Pauly either, so you'd be able to successfully challenge Schedule 3 documents on that basis. So let's say that Dr. Busy at least produced the documents that he was able to do. How does he get paid for that? So the family law rules say that the minimum amount that must accompany a subpoena is $10, but as well as that $10, which is really just to cover some basic postage and photocopying, that amount's very rarely likely to be adequate, depending on the number of documents you have and the distance from the registry. So the family law rules actually say that you're entitled to be paid conduct money at the time of service that's sufficient to meet the reasonable expenses of complying with the subpoena, at least equivalent to the minimum amount in Schedule 4, so that's the $10, and you have to be paid that money at the time of the issue of the subpoena or immediately after. The rules also say, and this is important, that you're entitled to be reimbursed if you incur a substantial loss or expense that's greater than the amount of conduct money or witness fees payable under the rules. Now, this is different from the power of the courts to issue costs. So if you think of it this way, conduct money is what you actually need to get the documents to court. Costs in family law proceedings really relate to legal costs and what you're entitled to be reimbursed. So this comes back to that substantial loss or expense argument, and the court said that you're entitled to reasonable legal costs. So in other words, you can claim the cost of getting some advice about whether or not you have to comply with the subpoena. You're also entitled to reasonable transport to and from the court. Generally that's regarded as public transport, but let's just say you lived in or practiced in Murringan, which is on the outskirts of Toowoomba and has no public transport that I know of between there and Brisbane, then the rules say that you're entitled to a per kilometre basis to and from the court, which at the moment is 80 cents a kilometre. Now, whether or not you're entitled to all of your legal costs will depend on whether or not you get costs on what's called an indemnity basis. And the court said that it's not the usual thing for people to get costs on an indemnity basis, and that you have to have exceptional facts in order to do so. The sort of factors that can lead to indemnity costs are the volume of material sought and the attempts that were made to obtain the material before the issue of the subpoena. So going back to that Dr. Busy example, a huge volume of material was sought, and there was no attempt to seek that material from the doctor before the subpoena was issued. And in those circumstances, it is likely that the doctor would be able to get his costs on an indemnity basis. So, in thinking about that, I suppose it's important to think once again of the purpose of the issue of a subpoena, and that is that it's really part of your duty as a citizen in administering justice. And Justice Murphy, who's a very senior and highly regarded judge in the Family Court at Brisbane, has written a lot in recent years about subpoenas, but he gave this example in a case earlier this year where he was very critical of the fact that the husband had issued a subpoena which sought a huge number of documents, but he still didn't order indemnity costs. He said, I take into account that this exercise not only caused costs to be incurred, but also inconvenience to persons whose privacy should be protected. inconvenience is something that society has to bear as the price for a functioning judicial system. So it's the expense rather than the inconvenience that the court should consider important. Whilst the course adopted by the husband should not be encouraged, I'm not persuaded that this is a case which falls into the category of a very great departure from the normal standard. But this gives you an example of the sort of costs that if you sought legal advice you would be able to claim. So the cost of reviewing that subpoena and really looking carefully at what documents were sought, the cost of initial legal advice in relation to whether you have to produce the documents and if so, which ones, writing to the solicitors who issued the subpoena and seeing if you could narrow the scope of the subpoena, remember that you're supposed to produce the documents even though you're objecting to them, so actually looking at all those documents, drafting the objection to the subpoena, drafting submissions about why the scope of the subpoena should be narrowed, leaving the office to go to Brisbane and come back, and then the travel. And in that particular example, those costs were $4,608. So you can see from that example that the $10 or $5 that was issued and the $10 in the rules were wholly inadequate to meet all of those costs. And once the lawyers for Mr. Pauly were aware that if the scope of the subpoena wasn't narrowed and the objection was maintained, that the costs were in that vicinity, they would have been crazy not to agree to narrow the scope of the subpoena. So generally, once that happens and the subpoena is narrowed, you should be able to just post your documents to the court registry. Don't post them to the party who issued the subpoena because you can't. As I said, it's the court, not the party, who's actually responsible for the subpoena, and a party who issues a subpoena has to actually apply to the court to get leave to inspect those documents, so you don't get the right to do that without actually asking the court for permission to do so. The other thing I should tell you is that if you go back to that objection to the subpoena, you'll see that there's a part on that where you can object to, you can produce the documents, but then objecting to a party actually inspecting or copying the documents, and that's not uncommon with people with very severe mental health problems or perhaps medical problems of a very private nature where there's some sort of concern that the issues that are raised in the documents aren't really relevant to the proceedings, and it's not uncommon for the judicial officer to give the parties leave to look at some of the documents, but not all of them. So if you want to object on that basis, you need to do so once again at the time that you're returning the documents. Once you've done so, it'll be too late. The other thing you need to know is medical records particularly are unlikely to be able to be copied except by an independent children's lawyer. So that's a lawyer whose job it is to make submissions to the court about what's in the children's best interest. And the court can impose conditions upon inspecting the documents. Sometimes if the documents are very sensitive, they might say that only legal representatives can look at them. It's more difficult obviously when a person's self-represented, but even in those circumstances they might get the lawyer on the other side to summarise the documents for that person. So let's just say you've complied with the subpoena, you've sent all the documents to court, but you want to get them back. What happens then? The practice in the family court, and I should tell you that the family court registry is both the registry for the family and the Federal Circuit Court. So although they're two different courts, they're co-situated in the same building and the same staff are responsible for the file. they'll destroy the documents at the end of the appeal period unless you specifically seek to have them returned. So it's better to provide copies rather than original documents so that you don't have a problem about losing your file. Generally, you're entitled to be paid for reasonable photocopying costs. So in other words, you can claim the cost of photocopying your file. But remember, you have to object before the return date. So if you're copying a huge file and the amount of conduct money you've been given is inadequate, remember to contact the issuing party before the return date and say, look, the $10 wasn't enough, I'll need X to photocopy them. So in summary, these are my tips that I hope you take away from today. You should read the subpoena carefully. You're only required to produce the documents specifically requested in the subpoena. Sometimes recipients of subpoenas are really helpful and give you the documents they think you're seeking, but you don't have to do that. You only have to provide what was requested. You don't have to manufacture documents in order to comply, but if you can reasonably obtain a document, for example, from an electronic record by printing it out, then you're required to do so. Before you object, you should contact the party who issued the subpoena, preferably in writing, so you've got a record of it, which will be relevant to costs, and see if you can agree to narrow the scope of the subpoena or get them to agree to give you reasonable conduct money. If that doesn't work and you wish to object or seek greater reimbursement, you must do so before the return date. That subpoena document that you'll be served with has a part for objection in Part F. Make sure you complete that and return it. But if the subpoena wasn't from the family court, then check the rules related to the specific court or tribunal, because that'll tell you how you should object. And be prepared to take all the documents subpoenaed to court so that the judicial officer can determine what, if anything, is required. So thanks for joining with me today, and I'm happy to answer any questions. That's a good question. I was going to address that. The question is there a set hourly rate for the doctor's time? The answer is no. It's always a question of what's reasonable. But the other thing I meant to say, I didn't find a case relating specifically to a doctor, but there are quite a few cases involving lawyers who are subpoenaed to produce documents, and it's different when you're required to give evidence. Generally, you can claim reasonable time away from your practice, but because we are subpoenaed to produce documents, you can post them to the court and not be away from your practice. You wouldn't generally be entitled to an hourly rate or, for example, loss of profits for the day you missed work. So I know that's a fuzzy answer, but it's just what the court regards as reasonable on the day. Can the court order you to appear in person? Only for a subpoena to give evidence. If it's to produce documents, the rules say that you do have to appear in person to object, but you can do that through a lawyer. And given the sort of costs I indicated that you can claim for getting a lawyer to object for you, it probably would be more worthwhile for you to engage someone to do it for you. Because once you've tried to narrow the scope of the subpoena beforehand, if that wasn't successful, and if the subpoena was drafted in that really wide way that I illustrated, and unfortunately you do see a lot of subpoenas like that, you'd probably be successful and get at least the bulk of your costs back. So it probably wouldn't be worth your time in actually leaving your practice to do it. And then the next question was dollar rate at the time to actually produce the documents. Once again, there's no set fee, but it wouldn't be the dollar rate for the doctor to do it. It'd be a reasonable administrative fee. So, you know, I don't know what that would be, but maybe $40 or $50 an hour. But the court has to decide that it's reasonable. What if so the question is, what if my objections are rejected, any appeal? And the answer is yes. So generally in the family court, a registrar is the person who decided at first instance, and you can appeal to a single judge if your objection's unsuccessful.
It looks like you've either explained everything totally for them, Lisa, or they're totally confused, and they'll have to contact you at a later stage.
Well, Ted, I'm really happy for them to have the PowerPoint presentation, and if anyone's got any questions, feel free to email me.
Yep, that'd be great. So, if at some stage now after the webinar, if you do have a question that you want to ask, either direct to Lisa at Murdoch Lawyers or through us at GP Connections, we're more than happy to pass it on for you. If we have no other questions, just like to say thank you once again to Lisa. Very much appreciated for your time, and hopefully if any of us receive a subpoena, we've at least got some idea of what to do now.
That's right. Okay, thanks, Ken.
Thanks a lot. Bye.
Bye-bye.